With the Rahimi decision that came down last week, we have now gotten through the weekend. We're starting to see some of the aftermath here in California and from the federal government. Let's talk about it. Hey everybody, welcome back to the channel today. As promised, we have come back to visit the Rahimi decision. We put out a video a little bit earlier just letting everybody know that the decision had dropped first glance at it. We were now able to bring on President of CRPA, Chuck Michelle, to talk about it in further detail and the aftermath. Chuck, thank you for being with us today.
Always a pleasure, guys. Thanks for having me, and thanks for helping get the word out.
Absolutely. But before we get into that today, guys, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms. We want as many people to have this information as possible, especially when going to the ballot boxes this year in November for the general election. So Chuck, at the risk of sounding a little bit pessimistic, I wanted to discuss just sort of the overall aftermath that we're seeing with Rahimi. I know that it's been anticipated for a little while. We've been looking forward to, and we've been talking about the potential for clarification on the Bruin precedent that's been set, but a couple things have happened. So first of all, let's just round about this decision. Jacob, if you can bring this up on the screen, and guys, this isn't necessarily what somebody like we were looking for, the specific decision. But Chuck, I wanted to get your thoughts on this. This is the actual decision that Zaki Rahimi himself was found not to be in favor of as far as the decision. Justice Roberts writes this: bearing these principles in mind, we conclude that Section 922G8 survives Rahimi's challenge. And here's the provision in constitutional as applied to the facts of Rahimi's own case. Recall that the law provides two independent bases for liability. This law bars an individual from possessing a firearm if his restraining order includes a finding that he poses a credible threat to the physical safety of a protected person. Separately, this law bars the individual from possessing a firearm if his restraining order prohibits the use, attempted use, or threatened use of physical force. Our analysis starts and stops with 922G8CI because the government offers ample evidence that the Second Amendment permits the disarmament of individuals who pose a credible threat to the physical safety of others. So Chuck, my question to you is, because in our last video that we talked about this, you were hoping that the scope would be minimal if the decision did not favor Rahimi. Is that what you get here? Is this a limited scope in their decision to not be in favor of him?
Yes, it's applied only to Mr. Rahimi, and it only says that people who are subject to a restraining order because they have been found to be dangerous, those individuals can be disarmed temporarily. It doesn't even say permanently. So we expected that Mr. Rahimi was not going to preserve his right to keep and bear arms after he had a hearing with notice and opportunity to be heard, and he was found to be a danger. And we didn't think he was going to get his individual rights back. What we were afraid of was some kind of a sweeping ruling that would have said anybody with a restraining order, or anybody who smokes cannabis, or anybody who has a nonviolent misdemeanor or felony conviction could be banned as a category. And it did not go that far. Just dealt with him individually, which is good. It also clarified a few things, but did not clarify as much as we really need clarified. It clarified that you can't ban somebody from possessing firearms because they're irresponsible. They have to be dangerous. And that's significant because in LA County, for example, the sheriff is turning down people who apply for a CCW because they are finding them to be irresponsible because they got a gun stolen at some point, or they had a TRO that restraining order that expired, 10 years ago. Things that the sheriff is subjectively interpreting to be irresponsible, and that's not a prohibiting factor. That's not something you can deny someone their rights over. They have to be dangerous. But so there were some good things. They also didn't get into this, walk into this trap that the government. Keep in mind, the government wanted to get Bruin thrown out entirely, and this decision reaffirms Bruin and Heller by 8 justices, including the liberal justices. They all acknowledge that Bruin and Heller is the law. So the government failed to overturn Bruin or to get Bruin thrown out. What they did do is they held up. Remember, the test in Bruin was: does the text of the Second Amendment cover it, the right of the people to keep and bear arms? And the governments that are against gun ownership have been trying to limit who the people are and limit what arms are protected. And so they say, for example, a magazine is not an arm, so a magazine gets no Second Amendment protection. Well, those kind of things are getting litigated. But in this case, the Supreme Court did not open it up to some kind of reading of the text and interpreting the text to limit the Second Amendment application. It said all bearable arms. So that means, whether you can ban them or not, if they're bearable, they're still covered. Deciding whether you can ban them or ban a person or a place from being somewhere where the Second Amendment applies depends on whether or not there is some historical tradition in this country of being able to pass that kind of a law. So in this case, the Supreme Court pointed to two historical laws, which were very common back around 1791 and thereafter. It said if you appear dangerous, you can be forced to put up a surety. It's kind of like a bond that if you get in trouble, you lose all your money. And the other one was there are laws that prohibit people from going about the countryside and terrorizing people. If you do that, you can be disarmed. Those two laws were designed to take guns away from dangerous people. So the Supreme Court said, well, those are enough to indicate that the founders would tolerate disarming a guy like Mr. Rahimi. That's not a particularly surprising or unanticipated connection. Justice Thomas did point out that it doesn't really comply with the Bruin test. The Bruin test is supposed to be, you look at the historical law and see why they passed it and how they enforced it. And in this case, the why was to disarm dangerous people, which is fine. But the how was with surety or with laws against terrorizing the countryside. That's not the same how as a restraining order. And so Justice Thomas dissented, but all the other 8 judges concurred. Now, we're going to see, and we're already seeing, anti-gun owner governments like California and the Attorney General's office trying to spin Rahimi as an open, a free pass for governments to ban whatever they want if there's any kind of flimsy historical law that ever existed, including, one-offs in some remote town somewhere. So that's the fight we're going to now have to have. What exactly does Rahimi give the state the ability to claim is a relevant and similar enough historical law to justify a modern day law?
Well, yeah, I actually did want to come back to that because we have seen a couple of developments there. We've also seen some interesting things from some of the concurring opinions. I mean, I guess in total you're looking at 103 pages written by Supreme Court justices. You've got Robert's opinion, you've got several concurring opinions, and then Justice Thomas's dissenting opinion. I wanted to get your thoughts on this. This actually came out of Justice Jackson's concurring opinion. She writes this: the message that the lower courts are sending now in Second Amendment cases could not be clearer. They say that there is little method to Bruin's madness. It isn't just that Bruin's history and tradition test is burdensome. The more worrisome concern is that the lower courts appear to be diverging in both approach and outcomes as they struggle to conduct the inquiry Bruin requires of them. Scholars report that lower courts applying Bruin's approach have been unable to produce consistent principled results, and in fact, they have come to conflicting conclusions on virtually every consequential Second Amendment issue to come before them. Given this, it appears indisputable that after Bruin, confusion plagues the lower courts. Now, I guess, to be fair, like, she started off her concurring opinion by saying, I wasn't a Supreme Court justice at this time, but I would have objected to the Bruin decision. So she is no friend to the Second Amendment. She's made that very clear. I guess in my own lived experience, in a lot of these conversations talking with you, it doesn't really feel like confusion to me. It really feels like you have judges, whether it's a federal district court judge, whether it's a circuit court judge, who are constitutionalists and view Bruin as a resting place to rest their back on when they're making these decisions. And then you have other people who just don't want to abide by the precedent that Bruin has set. You can call that political action or what. I'm just sort of curious what your thoughts are as far as Justice Jackson is concerned here.
There's nothing. It's not confusing. Now, that's not to say that the Everytown law lawyers working for Bloomberg haven't sowed confusion deliberately to try and make it harder to strike down a law, particularly when you're dealing with a judge who doesn't want to strike down the law. But there's nothing confusing about it. The only reason that there are splits is because there are judges who faithfully apply Bruin, and then there are other judges who don't like Bruin, and so try to twist it around so that they don't have to strike down a law. That's not confusion. That's deliberate judicial disobedience to the Supreme Court's mandates. And that's what a lot of judges on the Ninth Circuit have been called out for by other judges on the Ninth Circuit. So this is not a particularly secret thing. This is political. It's very, very, some people feel very, very strongly one way or the other. Obviously, there's a lot of tragedies that go on when crazy people or simply evil people do horrible things and break multiple laws and committing murder. And the other side thinks if you ban guns, that'll stop. Of course, it won't. But because you can't uninvent technology, guns are here to stay.
Right.
But it's not confusion. It's the fact that the Supreme Court could not anticipate every way that a slick lawyer could twist their words in Bruin to give a judge who wants to uphold a law, an excuse, a way to do it, a reed to hold on to be able to do it.
Well, and then we see others starting to fan those flames. That rhetoric like that ends up providing fuel for. As you sort of already alluded to, we've seen the U.S. Attorney General Merrick Garland already put in a letter appealing to the Supreme Court, asking them to take on more cases like the Rahimi case. And even here in California, we've seen Attorney General Bonta appealing to the Ninth Circuit judges presiding over the Duncan case. Jacob, if you could pull this one up, he writes this letter to them. It says, applying the appropriate methodology, and you guys, he's referring to the Rahimi decision here, the court had no trouble concluding that the historical analogs invoked by the government were sufficient to justify the challenged law, even though those analogs were by no means identical to 922 G8CI. Here, the principle emerging from the long tradition of government restrictions and prohibitions on especially dangerous weapons and accessories justifies the challenged restrictions on large-capacity magazines. Chuck, I guess my question is simple. Once you actually get in the courtroom and you're arguing these things, do they get applied like this? I mean, is this even consistent with Justice Roberts' decision in Rahimi, let alone the Bruin decision?
No. But this is the games they're going to play now. They're going to act as if Rahimi was an open ticket for them to pass any law they want. But the Rahimi did not get rid of Bruin. It did not get rid of Heller. In fact, it reinforced those decisions. And you still have to have you don't have to have an identical historical law. It doesn't have to be. There was no semi-auto bans. There were no semi-autos. In 1791, there were things on their way to becoming that, but you don't have to have an identical. No one ever said you have to have an identical law. You have to have a law that is similar in why it was enacted and how it is enacted, what it does with a modern day law, and that's still the law. So we're going to see similar letters from AGs in Illinois, in others in New York, all the battleground states,
Right.
To try and use Rahimi to open a door for them to make an argument that they don't have to have, they can use any flimsy law from 1791 to justify a modern day law that's on a completely different topic and goes about it a completely different way.
Well, and certainly the Rahimi case was not the only case that we have been looking forward to from seeing an opinion from the Supreme Court. There are plenty of other cases. I'm sort of curious, now that this decision has been handed down, what is there to look forward to, and overall put Rahimi on the scales of justice? Does it help the 2A movement? Does it not help nothing, or does it backtrack?
It's going to create, it helps us in some respects because it clarified a few things, not nearly enough. And it's going to put up some roadblocks that we have to get around by pointing out how they're misconstruing the Rahimi decision when the states make their arguments. But keep one thing in mind. The Ninth Circuit judges that want to uphold gun control laws, they don't need any more excuses. They don't need the Rahimi decision to uphold the laws. They were going to do it anyway. We have to get the Supreme Court to issue another decision, perhaps multiple decisions. And there are now at least 4, maybe another or 2 cases that have asked the Supreme Court to review the lower decisions: the Illinois semi-auto and magazine bans, the New York sensitive places law that invalidates your carry permit in most public areas. That the Supreme Court's going to decide, like within days. They're going to decide either tomorrow, Wednesday, Thursday, Friday, or Monday. So either the 26th, 27th, 28th, or the July 1st, we're going to have decisions from the Supreme Court about whether or not they're going to accept any of those cases and have those litigated next term, which will begin the first Monday in October.
Well, certainly a lot to look forward to there. Certainly still a lot to look forward to here in California and at the Ninth Circuit. We've kind of been assuming that a lot of this was hinging on some action by the Supreme Court. We're now starting to get action by the Supreme Court, which means the Ninth Circuit and the federal district courts likely to start moving again. Chuck, I want to thank you for coming on. I'm sure with all this action, we'll be having you on again soon, but I do know you're a busy guy, so thank you for being on here with us.
Folks need to know the CRPA is not backing off. We have multiple lawsuits in effect that we're litigating right now. We have multiple more lawsuits planned. And the Supreme Court has not hurt us and could conceivably still help us if they take some of those cases. So help the CRPA help you fight for your freedom and freedom for your children. We're in a battle for America's soul. The presidential election probably epitomizes that best. But CRPA is the tip of the spear here in California. So support us so we can keep doing the good work.
And guys, if you like to see videos like this and want more content, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms. It really helps build the channel up so we can get this information out to more people. Thanks again, guys. We'll see you on the next one.